debate that we have today on legislating for the withdrawal agreement is obviously covered in this white paper, and it seems to me that there are three key points within it. The first is the obvious issue of EU nationals, and I have always thought that it is really important that people who are here lawfully, who we allowed to come and invited to come, are protected in every possible way as if they were British citizens. That we're not the sort of country that applies retrospective legislation. And we as Conservatives on these benches should have a particular admiration for people whose motivation is to improve their own standard of living. People who travel halfway across a continent to a country where they don't speak the language, do so legally and lawfully, and then work hard to send money back to support their own families. If that isn't an admirable and conservative thing to do, I don't know what is. And it's not their responsibility that we have voted to leave the European Union. They came here under treaties we had agreed, and they will be entitled to remain here because that is the type of country that we are. Of course I give way to the Honourable Lady.
Does the Honourable Gentleman recognise, however, that settled status does not confer exactly the same rights that they have at the moment?
I think the rights they should have should be no better or no worse than those of British citizens. I don't think we should have a special category of people under EU law. I think the extra rights they've got under EU law have been a mistake and have been granted by the European courts without our intention. I think it's absurd that it is easier to bring in a dependent under EU regulations as an EU citizen than if you're a British citizen. That's not a fair law, and that, I think, is something that once we've left should not be continued, that people should have the same rights as the British. They shouldn't have better ones, but of course I'll give way again.
I thank the Honourable Gentleman for generously giving away again, but does he recognise that the initial settled status offer meant that a European citizen who went abroad to work for 2 years would lose it? This has now been extended to 5 years, but that is not what applies to a British citizen.
I think that in that we can be more generous. I'm in favour of generosity to people who are legally here and who have made their lives in the United Kingdom. There must be some point at which they separate their lives from the United Kingdom and haven't applied for British citizenship, that it might not be perpetual. But I think they should be looked after, they should be protected, and we should always remember that they came here legally and we are not a nation of retrospective legislation, and therefore we should protect them and be generous. And I happen to think, as my right honourable friend, the member for Wokingham, thinks, that other continental countries will reciprocate, because they're civilised nations. We're dealing with allies and friends, and therefore this should never have been a topic of negotiation. We should simply have set out our stall and said that's what we would do. And I'm glad that it's now clear that in the event of leaving on WTO terms, we will protect the rights of EU member state nationals who are living in this country. So that's the first point of the legislation on withdrawing from the European Union, and I'm all in favour of generosity. The second point is law, and this was covered obviously by my honourable friend, the member for Stone, who has such great experience in these areas. And here we were lucky that the Henry VIII clauses that were in the Withdrawal Act, as it now is, were by and large removed, because they would have allowed all the European law to be brought back through the back door. It had gone out through the front door, back through in the back door. And the Henry VIII clauses were removed, and therefore they need primary legislation. But this primary legislation is pretty dubious, because it is absolutely the vassal state. If you want another image, it is Gulliver tied down by the Lilliputians, this great nation state, tied down by petty bureaucrats, running all over us, tying us down with ropes, so that we will have to do whatever the European Union says we have to do for an implementation period. Our laws, our senior law, will be made by a foreign body in which we have no say, no vote, no association. Our money will go to this, but of course I give way.
Which Europe are we dealing with here? Are we dealing with one that's all friends and civilised countries and would never knowingly do anything bad to us? Or are we dealing with a lot of little miniature people who want to tie us down and presumably leave us to drown when the channel comes in? Or has he got a way to prevent the channel coming in next time the tide comes up?
I think the honourable gentleman is confusing me with the much maligned late Majesty King Canute, who is accused of trying to hold the tide back, but of course he didn't. He wanted to show that it wasn't possible to hold the tide back. But no, the bureaucracy of the European Union is something to which I'm strongly opposed, but that doesn't mean that I don't admire the individual member states and think of them as great countries and friendly allies. The two are completely different. And even if they weren't, even if they were the same, I may have a great friend, but I wouldn't want him to rule my life. And that doesn't seem to me to be any logical connection. But of course I can wait.
Would he not also accept that looking around the whole of the European Union at the moment, whether it's Italy or whether it's just most recently in Sweden and in all sorts of countries, many of them, in fact almost most of them, they're voting with their feet against this restriction on their right to make their own decisions in their own parliaments?
Well, as so often, the United Kingdom is leading by example, and there's that great quotation from Pitt the Younger: we have saved ourselves by our exertion, and we will save Europe by our example, and that is something that we should always remember as we make this great exertion, and worthy and noble exertion. But having a period of 21 months when our senior law cannot be stopped in this country, when our senior court is the European Court of Justice, is a great mistake and is a bit of the legislation that I, for one, will find it extremely difficult to vote for, because there was another way. There is an alternative route to do it, and in terms of the court, it's what we do with our own court in relation to human rights challenges. That if the domestic court decides, the Supreme Court, that a bit of primary legislation fails to meet the requirements of the Human Rights Act, there is a fast-track way of amending legislation through statutory instrument. But that means that if the House of Commons is against the change and wills to make the move that is against the Human Rights Act, it is free to do so. And that maintains control with our democratic processes. And that is how the government should be doing it in relation to ECJ judgments, or CJEU judgments, if you prefer, during the implementation period. We would, in the normal course, want to accept them because we would still have the treaty obligations, but they should come to Parliament to be passed into our law by statutory instrument to give us a reserve power, and a straightforward reserve power, not to do it if we felt that was not the right thing to do. And the same equally should apply to new laws, because new laws being made by the European Union, over which we will have no say, could do specific damage to areas of our interest. Absolutely. They could be laws affecting the City of London, in which I have certain interests, and I draw people's attention to my relevant declarations in the members' interests. But they're not just my interests, they're the interests of the nation at large. And we want to protect them and prevent unfavourable legislation being passed over which we have no control. And the best answer Her Majesty's government has given to defend this ability of a foreign set-up to make laws for this land, something that I cannot think that any country has ever voluntarily agreed to before. Countries have become colonies, but normally that's because there have been a little bit of encouragement, usually at the end of a bayonet or a spear or some such. It's most unusual to volunteer to allow a foreign organisation to make your laws. Unprecedented. No, that's not quite true. The honourable gentleman from Glenrothes, a great seat which I once stood for, not with enormous success, in 1997, said from a sedentary position that Scotland did it, but Scotland did not. Scotland became part of a greater whole, and how many prime ministers have we had who have been Scottish and have led this country with great distinction? So we became one rather than simply farming out our legislation to somebody else. And the government's best answer? The government's best answer is the EU is so slow, so slothful and sluggish, that in the period of 21 months it couldn't institute any new laws, and therefore we shouldn't worry our little heads about this. Now, I think this is a really unsatisfactory answer. It is not impossible for the EU to move swiftly, as it has done in the past. It is a golden opportunity for the EU to legislate in a way that we don't like, and we will have no say at all. And I go back to the solution that I have said for the courts: no new law without a vote in Parliament, and not a scrutiny vote, because the European Scrutiny Committee, though a very important committee, has never been able to stop any directive or regulation coming in, and regulations have direct effect without any vote or scrutiny in Parliament anyway. It needs to be a vote as if for a statutory instrument. It is an abnegation of democracy to allow our law to be changed in this way, and is a part of this white paper that must be rejected. I give way to my right honourable friend.
But isn't it much easier than this? We just don't have the so-called transition period and get on with it.
Well, that's very tempting, and I would be delighted to talk about that proposition, but the title of the debate is legislating for the withdrawal agreement, so I feel that I have to stick to the terms. Otherwise, Mr. Deputy Speaker, who I understand had a very nice holiday in France, showing our continental cousins that we still send them our finest and our best to go and show them.
I think for a matter of clarification, I was actually looking around the First World War battle and I want to see the VC winner from Chorley's grave. So it was essentially not a holiday. Jacob Rees Mogg.
I do apologise. Now, I understand there was a haircut whilst you were abroad that was reported in the national newspapers, which should be brought to the attention of this House. But the third point is money. And money is really important because the Honourable Lady intervened earlier on my right honourable friend from Wokingham to say that we're the sort of country that pays its bills, and that is absolutely true. But the question is, what do we owe under international law? Yeah. And here, the most authoritative report, Brexit and the EU Budget, March 2017, produced by the House of Lords EU Committee. Now, you may say that an EU committee is stuffed full of Eurosceptics and would be bound to come out with a report unfavourable to the European Union. And that could possibly be true in the House of Commons. I used to serve on the committee, and it would be only fair to confess that most of us were followers of the great gentleman, right honourable, not right honourable sadly, honourable friend, the member for Stone. But in the House of Lords it's simply not true. It's made up of former law lords, it's made up of a former cabinet secretary, it's made up of people who by and large were in favour of our membership of the European Union. And the case that was explained in this very powerful document was if we leave under the terms of Article 50 without a withdrawal agreement, we owe no money. And the reason for this is that our obligation to pay any money would in normal circumstances depend upon the Vienna Convention on Treaties from 1968.
Correct.
And if we left under those terms without anything in the Lisbon Treaty or other EU treaties, we would indeed be liable for our share of the liabilities. But that convention says that if the treaty of the organisation to which you belong makes a different provision for leaving, then that provision is authoritative. And then you go back to Article 50, and the provision of Article 50 is that if you leave after 2 years without a deal, that's it. Exactly. There is no financial provision at all. So the £40 billion that we are talking about, of our constituents' money, of money that could be spent on other pressing needs, and every member of this House could identify a pressing need in their own constituency or for their own constituents or for the nation at large. That £40 billion is not a legal obligation, it is a charitable donation, unless it comes with a very clear quid pro quo. And the honourable gentleman, the opposition spokesman, from Greenwich and Woolwich, I thought made an excellent point on this in a very well-considered speech, that the opposition will be expecting a good deal of detail on the second stage. What are we going to? We had a report last week that we're going to have a 10-page document of a political agreement saying motherhood and apple pie is all fine and dandy. That would be £4 billion a page for waffle. Well, you may like waffles, you may prefer Belgian waffles, but £4 billion a page for waffle is not something I think any responsible member of Parliament could vote for. For what, after all, is the job and power of this House? How do we control the executive? It has always been by the provision of money. And if the executive wishes to waste British taxpayers' money, we must say no. So the answer, really, Mr. Deputy Speaker, is that we say yes to people who are living here and are generous, but we say no to being a vassal state, no to being tied down by Lilliputians, and we say no to squandering taxpayers' money.